All right, so I've been explaining to everybody how the Trading with the Enemy Act is a trust and a trust indenture. And then that's going to bring us into the Trust Indenture Act of 1939. Kind of funny how they all kind of tie in together. You got the Township Ward Maternity Act of 1921, bringing about the birth certificates and the registry of babies at the hospitals or the foundling hospitals, and leads you into 1933. All of this was planned, ladies and gentlemen, and it's important for you to understand that. But everything that was done actually benefits us when we learn how to use the system properly. All right. And that's all it's about, is comprehending how to utilize it for our benefit, because it was, in fact, created for our benefit, even though it at times feels that it's the opposite. But we're going to show you that that's not true. And in order to do that, you just have to become familiar with the terminology and the words and the language used. I'm going to try and zoom in here. Maybe without screwing it up too much so you guys can see it. So now we're going to go through the Trust Indenture Act of 1939. As amended through Public Law 111-72, approved October 2009, short title, Section 301. This title, divided into sections as follows, may be cited as the Trust Indenture Act of 1939. Table of Contents, Title 3, short title, 301. 302 is necessity for regulations. 303, definitions. 304, exempted securities and transactions. 305 is going to be securities required to be registered under Securities Act. 306, securities not registered under the Securities Act. So it's important to know that there are securities that are registered, and then again, there are securities that are not required to be registered, all right? 307, qualifications of indentures covering securities not required to be registered. And of course, you got to understand that there were securities prior to 1934 Securities Act and the 1933 Securities Act. Okay. 308, integration, integration, inter, in, integration of procedures with Securities Act and other acts. Section 309, when qualifications become effective, effect of qualifications. Sections 310 is eligibility and disqualification of trustees. A, persons eligible for appointment as trustees. B, disqualification of trustees. And C, applicability of sections. Sections 311, preferential collections of claims against obligor. Section 312, bondholders list, Section 313, reports by indenture trustee. Section 314, reports by obligor, evidence of compliance with indenture provisions. A, periodic reports. B, evidence of recording of indentures. C, evidence of compliance with conditions precedent. D, certificate of fair values. E, reticles as the basis of certificate or opinion. F, parties may provide for additional evidence. And Section 315, duties and responsibilities of the trustee. A, duties prior to default. B, notice of defaults. C, duties of the trustee in case of default. D, responsibility of the trustees. And E, undertaking for costs. Sections 316, directions and waivers by bondholders, prohibition of impairment of holders' rights to payment. Sections 317, special powers of trustees, duties of paying agents. 318, effect of prescribed indentured provisions. 319, rules, regulations, and orders. 320, hearings by commission. 321, special powers of the commission. 322, court review of orders, jurisdiction of offense and suits. 323, liability for misleading statements. 324, unlawful representation. 325, penalties. 326, effect on existing laws. 327, contrary stipulations void. And 328, separability of provisions. Section 302, Trust Indenture Act of 1939, May 27, 1933, Chapter 38, Title 3, Section 301, as added August 3rd, 1939, Chapter 411, 53, Statute at Large 1149, Necessity of Regulations. Section 302A, upon the basis of facts disclosed by the reports of the Securities and Exchange Commission, otherwise identified as the SEC, made to the Congress pursuant to the Sections 211 of the Securities Exchange Act of 1934 and otherwise disclosed and ascertained, it is hereby declared that the national public interest and the interest of investors in notes, bonds, debentures, evidence of indebtedness, and certificates of interest or participation therein, which are offered to the public, are adversely affected. One, when the obligor fails to provide a trustee to protect and enforce the rights and to represent the interest of such investors, notwithstanding the fact that a individual actions by such investors for the purpose of protecting and enforcing their rights is rendered impracticable by reasons of the disproportionate expenses of taking such action, and b concerted actions by such investors in their common interest through representatives of their own selection is impeded by reason of the wide dispersion of such investors through many states, and by reason of the fact that information as to the names and addresses of such investors generally is not available to such investors. Two, when the trustee does not have adequate rights and powers or adequate duties and responsibilities in connection with the matter relating to the protection of and enforcement of the rights of such investors, when notwithstanding the obstacles to concerted actions by such investors and the general and reasonable assumption by such investors that the trustee is under an affirmative duty to take action for the protection and enforcement of their rights. Trust indentures generally provided that the trustee shall be under no duty to take any such action, even in the event of default, unless it receives notice of default, demand for action, and indemnity from the holders of substantial percentages of the securities outstanding thereunder, and b generally relieve the trustee from liability even for its own negligent action or failure to act. So when we were talking about earlier in the Trading with the Enemy Act, how we have to indemnify the alien property custodian holder and the Secretary of Treasury, this lends to that fact that we have to indemnify them because they are the trustees, all right? And we have to indemnify them in case it causes us any harm, damage, injury, or loss so they can perform their duties, all right? When the trustee does not have resources commensurate with its responsibilities or has any relationship to or connection with the obligor or any underwriter of any securities of the obligor or holders beneficially or otherwise any interest in the obligor or any such underwriter which relationship, connection, or interest involves a material conflict with the interest of such investors. 4. When the obligor is not obligated to furnish to the trustee under the indenture and to such investors adequate current information as to its financial conditions and as to the performance of its obligation with respect to the securities outstanding under such indenture, or when the communication of such information to such investor is impeded by the fact that information as to the names and address of such investors generally is not available to the trustee and to such investors. 5. When the indenture contains provisions which are misleading or deceptive, or when full and fair disclosure is not made to prospective investors of the effect of important indenture provisions. So that would be a violation of Title 15, 1692E, false and misleading statements, and the enforcement on that would be found in Title 15, 78FF. Comes at, I believe, $1 million fine for false and misleading statements. It also comes underneath false and misleading and deceptive trade practices as well. 6. When by reason of the fact that the trust indenture are commonly prepared by the obligor or underwriter in advance of the public offering of the securities to be issued thereunder, such investors are unable to participate in the preparation thereof, and by reason of their lack of understanding of the situation, such investors would, in any event, be unable to procure the correction of the defects enumerated in this subsection. B. Practices of the character above enumerated have existed to such an extent that, unless regulated, the public offering of notes, bonds, debentures, evidence of indebtedness, and certificates of interest or participation therein, by the use of means that instruments of transportation and communication in interstate commerce and of the mails, is injurious to the capital markets, to investors, and to the general public, and it is hereby declared to be the policy of this title, in accordance with which policy all the provisions of this title shall be interpreted to meet the problems and eliminate the practices enumerated in this section connected with such public offerings. May 27, 1933, Chapter 38, Title 3, Section 302, as added August 3rd, 1939, Chapter 411, 53, Statute at Large 1150. Definitions. Sections 303. When used in this title, unless the context otherwise requires: 1. Any term defined in Sections 2 of the Securities Act of 1933 and not otherwise defined in this section shall have the meaning assigned to such terms in such Section 2. 2. The terms sale, sell, offer to sell, offer for sale, and offer shall include all transactions included in such terms as provided in paragraph 3 of Section 2A of the Securities Act of 1933, except that an offer or sale of a certificate of interest or participation shall be deemed an offer or sale of the security or securities in which such certificate evidences an interest or participation, if and only if such certificate gives the holder thereof the right to convert the same into such security or securities. 3. The term prospectus shall have the meaning assigned to such term in paragraph 10 of Section 2A of the Securities Act of 1933, except that in the case of securities which are not registered under the Securities Act of 1933, such terms shall not include any communication, A, if it is proved that prior to or at the same time with such communication or written statement, if any required by Sections 306, was sent or given to the persons to whom the communication was made, or B, if such communication states from whom such statement may be obtained, if such statement is required by rules or regulations under paragraph 1 or 2 of subsection B of Section 306, and in addition does not more than identify the security, state the price thereof, state by whom orders will be executed, and contains such other information as the Commission, by rules or regulations, deemed necessary or appropriate in the public interest or for the protection of investors, and subject to such terms and conditions as may be prescribed therein, may permit. 4. The term underwriter means any person who has purchased from an issuer with a view to, or offers or sells for an issuer in connection with the distribution of any security, or participates or has a direct or indirect participation in any such undertaking, or participates or has a participation in the direct or indirect underwriting of any such undertaking. But such term shall not include a person whose interest is limited to a commission from an underwriter or dealer not in excess of the usual and customary distributors or sellers' commission. 5. The term director means any director of a corporation or any individual performing similar functions with respect to any organization, whether incorporated or unincorporated. 6. The term executive officer means the president, every vice president, every trust officer, the cashier, the secretary, and the treasurer of a corporation, and any individual customarily performing similar functions with respect to any organization, whether incorporated or unincorporated, but shall not include the chairman of the board of directors. 7. The term indenture means any mortgage, deed of trust, or other indenture, or similar instrument or agreement, contract, including any supplemental or amendment to any of the foregoing under which securities are outstanding or are to be issued, whether or not any property, real or personal, is or is to be pledged, mortgaged, assigned, or conveyed thereunder. 8. The term application or applications for qualification means the application provided for in sections 305 or sections 307 and includes any amendment thereto and any report, document, or memorandum accompanying such application or incorporated therein by reference. 9. The term indenture to be qualified means A. The indenture under which there has been or is to be issued a security in respect of which a particular registration statement has been filed, or B. The indenture in respect of which a particular application has been filed. 10. The term indenture trustee means each trustee under the indenture to be qualified and each successor trustee. 11. The term indentured security means any security issued or issuable under the indenture to be qualified. 12. The term obligor, when used with respect to any such indentured security, means every person, including a guarantor, who is liable thereon, and if such security is a certificate of interest or participation, such term means also every person, including a grantor, who is liable upon the security, or securities in which such certificate evidences an interest or participation, but such term shall not include the trustee under an indenture under which certificates of interest or participation, equipment trust certificates, or like securities are outstanding. 13. The term paying agent, when used with respect to any such indentured security, means any person authorized by an obligor thereon, A, to pay the principal of or interest on such security on behalf of such obligor, or B, if such security is a certificate of interest or participation, equipment trust certificate, or like security, to make such payment on behalf of the trustee. 14. The term state means any state of the United States. 15. The term commission means the Securities and Exchange Commission. 16. The term voting security means any security presently entitling the owner or holder thereof to vote in the direction or management of the affairs of a person, or any security issued under or pursuant to any trust, agreement, or arrangement whereby a trustee or trustees or agent or agents for the owner or holder of such securities are presently entitled to vote in the direction or management of the affairs of a person, and a specified percentage of the voting securities of a person means such amount of the outstanding voting securities of such person as entitles the holder or holders thereof to cast such specified percentage of the aggregated votes which the holders of all the outstanding voting securities of such person are entitled to cast in the direction or management of the affairs of such person. 17. The term Securities Act of 1933, Securities Exchange Act of 1934, and Public Utility Holding Company Act of 1935 shall be deemed to refer, respectively, to such acts as amended, whether amended prior to or after the enactment of this title. Number 18. The term Bankruptcy Act means the act entitled an act to establish a uniform system of bankruptcy throughout the United States, approved July 1st, 1898, as amended, whether amended prior to or after the enactment of this title. And again, here you have all your cited authorities, the statutes at large, all right, very important to pay attention to. And when we come back, we'll be talking about exempted securities and transactions.